Welcome to the Immigrantinlaw channel. In this video, we will take a detailed look at the key changes in EU immigration laws that have taken place or will come into effect in 2026. This information will be useful for anyone considering moving to a European Union country. We base our analysis on official EU documents and recently enacted changes. In 2026, EU countries will begin to implement the provisions of the new Pact on Migration and Asylum, prepared at the European Commission level. This is a large-scale reform that introduces uniform rules for dealing with migration and asylum throughout the European Union. Importantly, this is not a single law, but a package of regulations. They will come into force in stages, and it is from 2026 that the new procedures will begin to be fully applied in practice in different EU countries. The main changes are as follows. Acceleration of the processing of asylum applications. For some applicants, especially those submitting documents at the EU's external border, accelerated procedures will be introduced. Decisions on such cases will be made more quickly, and the requirements for documents and identity checks will become stricter. Stricter initial border controls. Before the start of the protection procedure, a uniform EU-wide screening will be carried out to establish identity, collect biometric data, and check security databases. These rules will become mandatory for all countries at the EU's external borders. A new system for distributing the burden among EU countries. If one country experiences increased migration pressure, other states are obliged to participate in providing assistance by accepting some of the applicants, providing financial support, or assisting with return procedures. This strengthens the role of pan-European mechanisms in determining where a person's case will be considered. Tighter requirements for security checks and data exchange. The use of pan-European databases, including the Eurodac system, is being expanded. This allows for more accurate tracking of applicants' movements and faster detection of repeat applications in different countries. As a result, the Pact makes the EU's migration system more unified and centralized. Procedures are becoming faster, but controls are becoming stricter, and decisions are increasingly being made on the basis of pan-European rules rather than just national norms. From 2026, the Schengen area countries will gradually begin to fully implement the Electronic Entry or Exit System, EES, a digital database that records the crossing of the EU's external borders by third country nationals. This system is being implemented throughout the Schengen area and replaces the familiar system of passport stamps. Now, upon entry and exit, passports are no longer stamped. The date and place of border crossing are automatically recorded in the common electronic system. Biometric data is collected, including fingerprints and a photograph of the face. The recording of the length of stay is fully automated. The system itself calculates whether the permitted period of stay in the Schengen area has been exceeded. This means that the human factor in calculating the number of days of stay is virtually eliminated. Even a one-day overstay will be recorded in the system and may affect future visa decisions or entry permits. This is especially important for travelers, workers, and those planning to move. The EES directly affects how your migration history will be assessed, whether you complied with the deadlines, whether there were any violations, how long you actually stayed in the EU. This data becomes available to the migration and border services of all Schengen countries. Even countries that are not on the EU's external border participate in this system through a common database. For example, when you travel further within the Schengen area, information about your initial entry will already be available to national services through pan-European data exchange systems. As a result, controls become less visible, but much more accurate technically. For you, this means one thing. Any trips, short visits, or long stays must now be planned with particular care in terms of timing and legal status. In 2026, the European Commission, together with a number of member states, is tightening measures against irregular migrants, those who have been denied protection status or are detained without legal grounds for staying. This direction is part of a new pan-European strategy to combat illegal migration and strengthen migration control. Specific changes include speeding up deportation procedures after protection has been denied. Deadlines for enforcing decisions are being shortened so that such decisions are carried out more quickly and effectively. Introducing long-term re-entry bans. In some cases, restrictions can be up to 10 years, which will make it much harder to return to EU countries after deportation. Strengthening cooperation with third countries on return issues through bilateral agreements and coordination of deportation operations. These measures are aimed at making the EU migration system more rigorous and predictable. If a person does not obtain legal grounds for residence, their stay will end more quickly and with more serious consequences for future visa and migration opportunities. In 2026, Denmark initiated reforms to its national migration legislation aimed at strengthening control over foreign nationals who break the law. These proposals are being discussed in the context of a Europe-wide trend towards tightening migration policy. Key measures include the possibility of deporting foreign nationals convicted of serious crimes, especially if a prison sentence has been imposed, the use of electronic monitoring devices, including bracelets, for persons subject to restrictions or expulsion procedures, simplified and faster procedures for revoking asylum or residence permits in cases of serious violations of the law or conditions of stay. Such initiatives reflect a general trend. Individual EU countries are seeking to expand their powers in the field of migration control, even if this raises questions about the balance between national measures and European standards for the protection of human rights. Against the backdrop of tightening rules in a number of countries, the reform approved by the Spanish government stands out as a notable exception. It aims to legalize a significant number of foreigners already in the country. The main provisions include the possibility of legalizing their stay for approximately 500,000 people living in the country without full status. Those who were in Spain before the end of 2025 or have already applied for international protection are eligible to participate. Procedures are simplified for individuals without a criminal record and who meet basic integration requirements. This step underscores that migration policy in the EU remains heterogeneous. Despite a general tightening of controls at the union level, individual states use regularization mechanisms based on their own economic and demographic objectives. In 2026, Croatia will adapt its migration and border rules in line with new EU requirements and current challenges at its external borders. One of the key changes is amendments to the National Border Control Law, which have already been adopted by the country's parliament. The main features of the reform are: state authorities will be given more flexible powers for operational border control, including the ability to introduce targeted checks at specific sections of the border rather than only full border controls. These measures are aimed at improving the effectiveness of responses to situations of migration pressure, security threats, or other risks to public order. The changes are in line with EU regulations and require notification of European institutions when temporary measures are introduced, which enhances transparency and compliance with the principles of freedom of movement. In addition, Croatia continues to work on strengthening its national migration system in line with common EU standards. For example, by implementing new rules for issuing residence permits and adapting to the arrival of the Single Electronic Entry or Exit System, EES, which will come into effect in April 2026. These steps reflect a trend. Even countries with low migration pressure are seeking to ensure both border control and compliance with pan-European rules, while maintaining a balance between security and legitimate opportunities for entry, work, and residence. In 2026, Romania continues to adapt its migration legislation to European standards, while strengthening the regulation of labor migration in response to the needs of the economy. Key areas of change. The government approves an annual quota for work permits for third country nationals, which has remained high in recent years due to labor shortages in a number of sectors. Control over employers hiring foreigners is being tightened, with more attention being paid to working conditions, the reality of employment contracts, and the prevention of fictitious employment. Procedures for issuing and renewing permits are gradually being brought into line with new EU standards, particularly with regard to data exchange and verification of legal residence. As a result, Romania remains a country with relatively accessible opportunities for labor immigration, but the rules are becoming more formalized and transparent, and control over compliance with the conditions of stay is becoming stricter. The temporary protection regime applied in the EU in the event of a mass influx of people due to exceptional circumstances has been officially extended by a decision of the Council of the European Union until March 4, 2027. This status entitles beneficiaries to legal residence, access to the labor market, basic social support, and medical care without going through the full asylum procedure. However, it is already important to consider further changes. After March 4, 2027, the temporary protection regime at the EU level will end unless a new separate decision is adopted. Member states are preparing mechanisms for transitioning to other legal grounds for residence, such as obtaining a residence permit for work, business, study, or family reunification. A number of countries are discussing or developing national transition schemes to enable people who are already integrated into the labor market and society to retain their legal status after the end of temporary protection. This means that the legal status of persons in the EU under temporary protection will change in 2026-2027. It is therefore important to plan ahead for your future residence status, especially if you are working, running a business, or planning your future in one of the EU countries on a long-term basis. So, let's summarize and break down what all these changes mean for you personally if you are planning to immigrate to an EU country in 2026 or later. Stricter border controls. With the launch of the EES system, every time you cross the border is automatically recorded. This forms your digital migration history, how many days you have spent in the EU, whether you have exceeded the time limits, and whether you have complied with visa rules. Even minor violations are now visible to all EU migration services and may affect future visas, residence permits, and entry permits. New asylum procedures. The processing of applications may indeed become faster, especially when submitted at the EU's external borders. But at the same time, checks are being tightened. More attention is being paid to documents, entry routes, biometric data, and the accuracy of the information provided. This means that you need to prepare your application more carefully than before. Tougher deportations. If protection is denied or the rules of stay are violated, return procedures become faster and stricter. In addition to leaving the EU, long-term re-entry bans are possible. This seriously affects future immigration plans and makes compliance with EU status critically important. Opportunities for legalization. Despite the general trend toward tightening, some countries are maintaining or introducing simplified regularization programs for those who are already in the EU and meet the established conditions. An example is Spain, where large-scale legalization mechanisms are in place for certain categories of foreigners. This shows that with a competent strategy, even under new conditions, there can be legal paths to stable status. Overall, the EU immigration system is becoming more digital, centralized, and strict, but it remains predictable. The more carefully you follow the rules and plan your steps in advance, the higher your chances of a successful and safe move. 2026 is an important milestone in the development of EU migration policy. We are seeing two processes simultaneously. On the one hand, increased control, digitization, and stricter procedures. On the other hand, the preservation of legal opportunities for relocation, work, and legalization with a competent approach. The main conclusion is simple. Spontaneous immigration is becoming increasingly risky, while a well-thought-out and legally structured strategy is becoming increasingly important. Under the new conditions, a transparent migration history, compliance with residence periods, and the correct choice of grounds for residence in the EU are particularly valued. If you are just planning to immigrate to the EU, leave a request for a free consultation with Immigrantinlaw lawyers. We will select the optimal relocation strategy for you, prepare all the necessary documents, explain the nuances of the legislation in detail, and answer all your questions. We will analyze your case, your goals, and your situation without templates. Want to learn more or start the process today? Contact us. All contact details are listed in the description below this video. We are here to help you take a confident step towards a new life. Like, subscribe to the channel, and ask your questions in the comments. I will be happy to answer them. Discover a world of opportunities with Immigrant in Law.